A living trust avoids probate because it's recognized as a separate legal entity, separate and apart from you. When you fund or transfer your property to the name of the trust, that's retitling the asset. The living trust owns the property. You don't own it. Therefore, your assets will bypass probate. But the trust has to be properly funded to avoid probate. It is critical and it is too often overlooked. We can assist you with the process of funding the estate. Further or more advanced planning can provide additional benefit. With proper planning, you can provide discretionary distribution. So I could say, I want to give the sum of $1,000 to my grandchild when my grandchild graduates college, when my grandchild has a religious ceremony, when my grandchild gets married. That's a discretionary milestone event. I set aside the sum of $50,000 in the event that my grandchild graduates secondary education or obtains an advanced degree, or you could earmark it to perhaps purchase a property for them. So you can accomplish other benefits unique to your situation. So if you have, there's a daughter first. If you have a daughter and you don't like your son-in-law, you can provide for money for your daughter and it will never go to your son-in-law. So a few years ago, I wrote a blog article and then I did a video about a salacious title based on inquiries I was receiving. And it was, how do I make sure that my daughter-in-law does not inherit my money? And that's how you do it. You can do it by within the content of your trust. This is a protection from the grave to protect future generations. So consider a living trust. To sum up the benefits, you'd want to consider setting up a living trust if you own a home or a property. Why? Because your heirs will receive a stepped up basis. They'll get the modified value of the home at your passing. You bought at $100,000. The property is now $1.1 million. It increased by $1 million. You don't want to transfer that during your life. We'd like it to pass at your own passing, pass at your passing, transfer at your passing. Your heir, your beneficiary receives the stepped up basis. You don't pay tax on that money. They receive it at the value of that later date. You consider a trust because you want your affairs to be managed the way you direct. You'd like your affairs to be governed in the way that you'd like if you became incapacitated. You'd like your affairs to remain private. No public proceeding, no court involvement by using a trust. Sometimes I get contacted. Used to happen more frequently. I think there's a lot of education in the trust field, but I used to get more frequently a house was transferred to children during the life, sometimes to avoid a nursing home, sometimes because the parent wanted to be helpful to the child, but that adult child will now probably pay capital gains should they sell it. If it was transferred for no consideration within 5 years of needing a nursing home, that nursing home may deny Medicaid coverage. I had a specific instance where two daughters received the property of the parent. They rented out the home and then they did not share the proceeds that rented our home to the parent. You'd consider a trust if you're single. A single individual has special estate planning needs. You have no legal partner that'd be recognized upon your incapacity of death. You have no marital exemption for estate taxes. You need a legal document to designate a manager of your estate if you become incapacitated. Have you thought about who you'd like to manage your assets or make your healthcare decisions after you become incapacitated? Who's going to be the beneficiary of your estate? If you want to name a significant other, perhaps you're in a committed relationship, but you're not married, that person is legally a stranger to you, you need a written estate plan. Most states don't recognize or protect non-relative domestic partners. Needs to be in writing within a plan.